On March 30th, 2021, the Ninth Circuit Court of Appeals ruled on certification requirements for service dogs. The short answer is no. Nobody can require certification of service dogs. Continue listening to understand the details of this case. CL is a speech pathologist with a PhD. She endured years of physical, psychological, and sexual abuse. Then, as an adult, she experienced a 10-year abusive relationship. CL has been diagnosed with PTSD, dissociative identity disorder, anxiety, and depression. Her mental health issues impact major life activities like interacting with others, self-care, and sleeping. CL's PTSD causes a heightened startle response and hypervigilance. She continually checks whether things in her environment are dangerous and finds it difficult to remain focused and engaged in daily tasks. Additionally, having people unexpectedly appear induces anxiety. CL has PTSD-related nightmares and flashbacks that are sometimes so severe that she tries not to sleep at all. In 2011, after an event triggered a traumatic memory, CL's mental health deteriorated and her flashbacks, anxiety, and depression increased. She felt suicidal and her therapist encouraged her to obtain a service dog to manage her symptoms. CL purchased a book called Training Your Own Psychiatric Service Dog by a service dog trainer named Katie Gonzalez. She realized that because she was living on a Social Security disability income, she could not afford a fully trained dog because that would cost at least $15,000. In 2013, CL obtained Aspen to be her service dog. She was a 16-pound poodle mix that was 8 weeks old. She used the methods she learned from the book to begin training her dog. Aspen learned to do the following tasks: waking CL from nightmares, improving her sleep and reducing the amount of distress she experienced afterwards, grounding CL during flashbacks and anxiety. Aspen would place herself on CL's lap and apply deep pressure therapy, thereby grounding CL in the present, alerting CL to approaching people, thus reducing her symptoms of hypervigilance and improving her ability to focus on the task at hand, interrupting CL's self-injury behavior of banging her head on the wall by placing herself between CL and the wall. Aspen was trained in cornering, which means Aspen would go around a corner ahead of CL and alert her if someone is approaching. Aspen practiced boundary control, meaning she enforced a boundary between CL and other people, enabling CL to spend more time in public. Aspen was trained to alert her when her anxiety is increasing even before CL becomes conscious of it herself, so she can take medication to prevent the severity of an anxiety attack. Standing guard by the shower, Aspen sits in a specific location outside the bathroom door and warns her by coming to get her if someone approaches. The Alamo National Treatment Center program CL was admitted to specializes in treatment of patients who have experienced trauma. During 7 of CL's admissions, the hospital denied her request to bring Aspen with her because the clinicians determined that Aspen's presence in the center would interfere with CL's therapy by allowing her to rely on Aspen rather than learning coping skills. In 2018, CL filed a complaint in the Central District of California challenging Del Almo's practice of denying admission to Aspen. A bench trial took place in 2019, and 2 issues were presented at trial: whether Aspen was a service dog and whether allowing Aspen to participate in CL's hospitalization would, quote, fundamentally alter, end quote, the psychiatric services that were being offered to CL during those hospitalizations. At trial, CL testified about training Aspen to perform the specific tasks previously outlined. Gonzalez, the book author, testified that her organization, called Little Angels, offers a certification for service dogs based in part on protocols developed by Assistance Dogs International, also known as ADI. ADI is a private, nonprofit organization of professional service dog trainers. ADI developed the protocols for service dog training as best practices by its members. Gonzalez emphasized, however, that the legal standard for determining whether a dog is a service dog under the ADA is different and more basic than the Little Angel certification or the ADI protocols. Gonzalez testified that she could not certify Aspen under the ADI's protocols because further steps would be required for her to do so, like submitting the dog's veterinary records, remaining in contact with Gonzalez every month, and completing all of the Little Angel's seminars and assessments. Gonzalez observed CL and Aspen working together and concluded that the unit exhibited both classical and operant conditioning, forms of training that are common in the industry and used by Little Angel's trainers. Based on that, Gonzalez testified that even though CL did not complete the steps required for Little Angel's certification, CL had successfully trained Aspen as a service dog. Regarding the hospital's fundamental alteration defense, Dr. Anna Salt testified that having the dog present during hospitalizations would make it too tempting for her to try to utilize the service dog instead of implementing tools that are taught within the program. The lower court decided in favor of the hospital on the grounds that CL had not shown Aspen is a service dog. The court did not address the question of whether the hospital had proven its defense of fundamental alteration. CL appealed the decision. While the appeal was pending in 2020, several organizations filed an amicus curiae brief in support of CL. An amicus curiae is a statement from an impartial advisor to a court of law. The advisor is typically called a friend of the court. CL framed the issues on appeal as two legal errors by the district court: imposing a service dog certification requirement, which the ADA prohibits, and concluding incorrectly that her testimony requires corroboration to satisfy the ADA. The hospital argued that the issue before us is whether Aspen was a trained service dog and whether Aspen could perform tasks directly related to CL's disability. Agreeing with Del Amo, the district court concluded that Aspen is not a service dog on the grounds of credibility. The plain language of the district court's decision suggests that it relied on Katie Gonzalez's inability to certify Aspen under Little Angel standards to reject CL's claim that Aspen is a service dog. The court repeatedly emphasized certification standards in its judgment. Second, the court stated, Gonzalez testified that she believes Aspen is a service animal as of June of 2019, but that testimony was contradicted because Gonzalez is still not willing to certify CL and Aspen as a service dog and handler team. The court then concluded that CL had not met her burden of proof that Aspen is currently a trained service dog. In other words, Gonzalez's expert testimony that Aspen was a trained service dog as of June 2019, the only expert testimony implicating service dog training, was not accepted by the court because Gonzalez's inability to certify Aspen necessarily contradicted that claim. If the inability to certify Aspen contradicts an opinion that Aspen is a trained service dog, as the district court stated, then the court improperly considered certification to be a legally necessary standard for assessing whether Aspen was a trained service dog. Because the court declined to give weight to CL's testimony on its own and considered her testimony uncorroborated, the court's conclusion that Aspen was not a trained service dog hinged on the supposed contradiction in Gonzalez's testimony. Contrary to De Amo's contentions, the court did not challenge or raise questions about CL's credibility. The relevant question is whether Aspen was a trained service dog at the time of trial. The Court of Appeals had to decide if it was a misinterpretation of the ADA to require a service dog to meet formal certification requirements. The lower court erred by imposing a heightened requirement on Aspen that is inconsistent with the ADA. The ADA's regulations define a service animal as any dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability, including a psychiatric disability, where the work or tasks are directly related to the individual's disability. The regulations do not specify by whom the dog must be trained. Rather, the statute defines a service dog by the outcome of the training, meaning that what the dog is capable of doing helps alleviate an individual's disability. The language also makes it clear that the dog's capabilities must be trained for that purpose. A companion animal that just happens to do things to alleviate a person's anxiety would not suffice. But a dog trained by the individual to perform certain tasks to alleviate that anxiety would. The appeals court's view is consistent with the district courts that have considered the question and found that the ADA does not require a service dog to perform a particular number of trained tasks or an amount of work. And Aspen had been trained to perform several tasks well beyond the normal behavior of a pet. The DOJ has consistently stated that a service animal must be individually trained to perform tasks related to an individual's disability, but the animal need not be formally certified. The test is a functional one. Can the dog consistently help the person with a disability meet the challenges of life by assisting in the person's activities of daily living? DOJ regulations and commentary make it clear that individuals may self-train service animals without obtaining a formal certification. With regard to qualifying service animals, the DOJ amended the definition of service animal to exclude some species, such as rabbits, cats, etc., and to exclude emotional support animals, also known as ESAs, but it also sought to formalize the agency's long-standing position that people with psychiatric and mental disabilities can use service animals. The district court's ruling that Aspen was not a service animal, in part because she could not be certified under ADI standards, is contrary to multiple aspects of the 2010 regulations. First, the regulations state that a person with a psychiatric or other mental disability may benefit from the use of service animals. Trained tasks can include preventing or interrupting impulse or destructive behaviors. As other courts have noted, a dog can be trained to aid a person with a disability without formal schooling. The DOJ confirms that persons with disabilities are not required to have formal training and may self-train their animals. In fact, the DOJ considered, but specifically rejected, recommendations submitted by others to adopt formal training requirements for service animals. The DOJ justifies its decision by noting that a certification requirement would increase the cost of acquiring a service animal, thus limiting access to such animals for individuals with limited financial resources, and the suggested training standards were too lengthy and detailed. The DOJ emphasized that individuals with disabilities may be capable of training, and some have trained their service animal to perform tasks or do work to accommodate their disability. It is enough if a service dog has been trained to perform specific tasks that will consistently aid a person with a disability by making them more able to perform necessary tasks and enjoy activities of daily living. The appeals court ruled that the district court erred because requiring certification would hinder the goals of the ADA. The flexibility to self-train a service animal for an individual's specific needs furthers the ADA's goal of helping people with disabilities live with equality of opportunity, full participation, independent living, and economic self-sufficiency. A certification requirement would have negative consequences for persons with psychiatric disabilities who rely on service dogs. Research shows the significant impact animals can have on the quality of life of persons with such disabilities. CL's case illustrates the benefits that a trained service dog can provide to an individual with PTSD. CL testified that she is able to go into public much more because of Aspen's training in alerting her to the presence of other people. She also feels comfortable going grocery shopping with Aspen's assistance, which she was not able to do before. Enrolling in a training course to obtain a certification is not always a viable option for persons like CL who had not even been able to work before obtaining Aspen. The district court placed great weight on the fact that Gonzalez would not certify Aspen as a service dog under standards set by Assistance Dogs International, a private trade association, but Gonzalez explained that she could not certify Aspen under the standard unless CL attended 3 seminars and provided proof of disability from a medical provider. Those burdens were in addition to the $900 tuition, plus any travel or other expenses that may be required to attend multiple day sessions. More importantly, the DOJ declined to adopt formal training requirements precisely because the needs of each individual with a disability vary greatly. Thus, a ruling that service animals cannot be qualified under the ADA if an expert is not willing to certify the animal based on the standards of a private organization would have the effect of denying legally protected access to public accommodations for persons who, like CL, need service animals to mitigate the effects of their disabilities in these spaces. And from a pragmatic standpoint, there is no industry-wide consensus on the proper certification standards. For example, Gonzalez testified that her organization starts with the general certification framework of another organization, but then adds additional standards. It is unclear how a person like CL could reliably choose between these various standards, none of which the DOJ endorses to ensure the certification would be judicially recognized. Demanding a certification requirement would not create certainty for whether a dog is truly a service animal. Instead, it would multiply litigation over which certifications are judicially valid. Under the ADA, proper focus is on whether a service animal will consistently and reliably help a person with a disability in performing activities of daily living. The appeals court ruled that the ADA prohibits certification requirements for qualifying service dogs for 3 reasons. 1, the ADA defines a service dog functionally without reference to specific training requirements. 2, Department of Justice regulations, rulemaking commentary, and guidance have consistently rejected a formal certification requirement. And 3, allowing a person with a disability to self-train a service animal furthers the stated goals of the ADA because other training could be too expensive. The appeals court ruled in favor of CL under the ADA, which prohibits discrimination in places of public accommodations, including hospitals. The court vacated and remanded the lower court's decision. Vacated means that they set aside the previous judgment, and remanded means that they sent the matter back to the lower court from which it was appealed. Requiring certification of service dogs is illegal.